So, we discussed the Constitutional Convention, the basic outline of the Constitution, a lot of which we'll get into in a lot more detail when we cover the three branches of government one by one. And now we need to discuss the Bill of Rights, because it was at the Constitutional Convention that the Anti Federalists brought up the point of, you're giving way too much power to the federal government. This could be just as bad as the monarchy we were living under with the British. And in contrast to James Madison's views that he publishes into the Federalist Papers, we'll get into that in our next presentation on the ratification of the Constitution, the Anti-Federalists thought that an extensive large territory cannot be governed by a federal government in the principles of freedom, as they worded it. One of their biggest fears is that the Constitution would only benefit the wealthy, it would oppress the common person, and most of all, above all else, they feared a loss of their civil liberties. So you can see this political cartoon where they take the Uncle Sam, I want you to join the military, and they remade it to, I want you to give up your rights. And this has been used throughout history, this attitude, not necessarily this specific cartoon, to signify that people think the government is going too far with their power. So the biggest criticism not being a proper protection of civil liberties meant that some kind of deal needed to be made. And so what the Federalists, who supported the ratification of the Constitution very strongly, did to convince the Anti-Federalists to at least allow it to be released to the states for a vote. And we went over in our Constitutional Convention presentation how the vote was within about 6 months' time from the release of the Constitutional Convention's final product into an actual usable constitution. In order for that to happen, they needed the Anti-Federalist support. Because even if they were going to go out and speak against the Constitution, they at least needed it to be released to the public. So a deal was made where the Federalists said, okay, we will add a Bill of Rights where some amendments to the very document that we have written can codify civil liberties. So the First Amendment reads in its formal language, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. So let's go over that in more modern language. What does that mean? There are 5 main parts to the First Amendment. First, an individual's right to free speech, every individual citizen. Second is the press or the media's right to free speech, to be able to publish articles without fear of being sued and prosecuted, as long as you're not saying things that are untrue. That could be referred to as defamation of character. Number 3, freedom of religion. Number 4, freedom to assemble, which is protesting even if it's a crowd, as long as it remains peaceful. And number 5, freedom to petition the government, which is a written form of protest. You get signatures on a petition to convince the government of something. Now, all of the amendments, for the most part, are tied very specifically to incidents that happened in the colonial period. And the Anti-Federalists were utilizing those incidents to say, we need these liberties protected because look what happened in the past. One example I will give you here is the press's right to free speech. If you remember the Zenger case in the colony of New York, when John Peter Zenger wrote articles about the colonial governor, Sir William Cosby, and was arrested for libel, which is back then the equivalent of defamation of character. And his defense was, I didn't say anything that wasn't true. So He was acquitted, and it sets the stage for the First Amendment. I believe I mentioned this when we were learning about the Zanger case. Next up, we have a nice meme, I guess you could call it, but it's very much a political cartoon, where you have the Bill of Rights in the background, and you have "We are not camping. We are peaceably assembling to petition the government for a redress of grievances. And this is our permit." A copy of the Bill of Rights. So showing that as long as we remain peaceful, you cannot stop us from protesting. The Second Amendment formally reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." So, translate this. What does a well-regulated militia mean? It means limit the power of the military from gaining political power. Also, you have to signify between the term militia and what would be called regulars in this time period. Militia would mean any citizen that would be capable to taking up arms. And regulars would mean the actual standing army, where that is your job, that is what you do. And by having a well-regulated militia, meaning a well-armed citizenry, it would limit the actual military from gaining political power as it had in some other countries. Security of a free state. It is important for the country to remain a free one. You'll also notice the use of the term state and free state. They believed that it was the states where most of people's freedoms lied, and it was those states that needed to protect those freedoms from a possible threatening federal government. And then lastly, shall not be infringed. The citizens of the United States have every right to keep, which means to own, and to bear, which means to carry, firearms. This is probably one of the most controversial of the Bill of Rights because people believe that in a modern world there should be limitations. Others don't. Here's kind of a silly meme. A pro-Second Amendment person would reference this. The Second Amendment. Washington didn't use his right to free speech to defeat the British. He shot them. Meaning, if the colonists had laid down to the British at Lexington and Concord, then you would probably not have seen independence take place because all of their weapons would have been confiscated, which brings me to, this is the historical event that leads to the writing of the Second Amendment. And you're going to notice the things they deemed most important were done in order. Free speech, a free press, that was deemed to be the single most important issue, so they addressed it first. The right for citizens to be armed, to resist if a government was to become too powerful, was deemed the very next most important issue. Now, something we don't think about much today, because we have a modern military with military bases, there really isn't much of a need for the quartering of troops. But Amendment 3 reads, in its formal language, "No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." So even if there was a war going on and the government needed people to quarter soldiers, then they would need to do so in a very formal and legal way. And it is really this quartering in the colonial period, and I'll show you a visual, really, just a reenactment of sorts, where soldiers are forcing themselves into this man's home, and it is either to search his home, which would actually be addressed in our next amendment, Amendment 4, but it could also be that he was refusing to quarter a soldier, and they were holding him at gunpoint to force it. So it really comes down to, it was the forcing of citizens to quarter troops, which meant everything: feeding them, housing them, maybe even clothing them, certainly like doing their laundry, etc. all against their will and with no like compensation or anything from the government. Today we don't see this as a problem, but if in a time of crisis it was asked of citizens to quarter troops, it would have to be voluntary or congressionally ordered. Then it could be lawful, and even then you might have challenges in the Supreme Court. Amendment 4, in its formal language, reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the places to be searched and the persons or things to be seized." So, what is the translation of that? That citizens should feel comfortable that their privacy and personal property will not be searched without probable cause. If there is probable cause, the police must be provided with a search warrant by a judge. That warrant must specify where the search will take place and what they are searching for. One must read a warrant carefully because it may not allow the police to search every part of your home. It might be limited by the judge's decision. So they might be allowed to search your garage but not enter the rest of your home. And if you don't read carefully, you might actually allow them to search things that they are not permitted to search. You'll notice there was a typo. I just ask that you fix that. And here is an image of the police ready to burst into someone's home. This is a very controversial action, particularly if they are not announcing themselves. This is called a no-knock warrant. These are very controversial. I would venture to guess you will see a Supreme Court decision on whether this is constitutional or not for the police to not knock and announce themselves and present a warrant, but rather force themselves into a home. Now, what is a term that you remember learning in our last section about unreasonable search and seizure? If you remember, in the colonial period, the British would use writs of assistance to search people, their property, and they could do so whenever they wanted, for any reason, on anyone. So it is essentially a limitless search warrant. This would be hands down unconstitutional based on the body of the Constitution, but also, as they're codifying here, the Bill of Rights. So it's very important to know this term because it's very likely to be referenced on tests, probably the Regents exam. Writ of assistance. It's like a search warrant, but it's an unreasonable search and seizure of someone because it doesn't specify anything. It can be used on anyone at any time. Amendment 5, in its formal language. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself. Nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. There's a lot there. Very, very dense amendment. What does all this mean? You can't be put on trial without an indictment, which means that there is enough evidence against you to justify a trial, and this comes from a grand jury. So this is different from a regular jury. A regular jury is 12 people deciding whether you are guilty or innocent. A grand jury comes well before you are even put on trial, and they assess the evidence against you to say, yes, this should go to trial, or no, there's not near enough evidence, throw this case out. It also states, you noticed, the military. And the military can have its own court system for soldiers. No one can be put on trial for the same crime twice. That is called double jeopardy. No one can be forced to be a witness against themselves. That's what I plead the fifth in court often means. No one can be denied life, liberty, or property without due process of law, which means fair proceedings, fair court proceedings with formalities involved. And lastly, property cannot be taken by the government for the common good without just, which is just fair, compensation, which is just a payment to the owner. This is often referred to as eminent domain, where the government will take someone's property, but they must compensate them. And in the modern world, they often compensate them far more than the property is actually worth, so that no one can accuse them of being abusive. Now, what leads to a lot of these issues needing to be outlined in the Bill of Rights? If you remember, throughout our colonial period study, we learned about a lack of due process for the citizens of the colonies. And due process of law, again, just means that you're going to be treated fairly in a very formal court proceeding. Due process of law. And next, the seizure of property. Not only were people, as outlined in Amendment 4, mad about being searched unreasonably, but sometimes their property was seized. In Boston, for example, merchant John Hancock, very wealthy man, was tossed out of his house so that the new colonial governor, General Thomas Gage, could live in his home. So this is really controversial stuff that needs to be properly outlined by the Bill of Rights. And you can see here probably the most well-known piece of the Fifth Amendment, and that is the I plead the fifth. You don't need to speak against yourself in court or say something that might work against you in court. So Amendment 6 in its formal language reads, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." What does this really mean? It's got to be a speedy and public trial of any accused person. The jury shall be, as we word it today, of your peers, which means of normal citizens from your region or area. You must be informed of the crime of which you're accused. You must know the witnesses for the prosecution who will speak against you. You must be given time to gather your own witnesses to speak on your behalf, and you are entitled to a lawyer to speak on your behalf. Now, even though this really only, as far as connections to the colonies, goes back yet again to a lack of due process in the colonies, what this is a sneak preview of, and something we will learn later in the course, is a period where the Supreme Court was very concerned with rights of the accused and whether the rights enshrined in the Bill of Rights were being properly provided. And many of those rights that were addressed, this is in the 1960s that we will come back to this, many of those rights come from this very Sixth Amendment. And what we now know of as your Miranda rights, it probably popped in many of your heads while reading this amendment and what it meant. This is all part of this trend of clarifying the rights of the accused in the 1960s. And we'll come back to this, but I wanted to mention it before we got all the way to covering the 60s later in the year. You can see here a man being arrested. He is most likely being read his rights as he is being arrested so that he is aware of what those rights indeed are. Amendment 7. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. What does that mean? Obviously, the lawsuit number of $20 has been adjusted for inflation over the years, or everything would require a jury. But if a fine or lawsuit is above the figure used, the person is entitled to a jury trial. Anything smaller than that means that just a judge can decide on that. So again, we come back to this term. I'm mentioning it for, I think, the third time now. And you are entitled to certain due process rights, and they wanted, based on what had been denied by the British during the colonial period, be very specific about what that meant, even when it came to lawsuits. So again, if you have something that is less than or equal to $20 in the colonial period, it's been adjusted, then you get a judge who decides your fate. If you have it greater than $20, again, adjusted for inflation today, then you get a jury. Amendment 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. What does this mean? A criminal's bail shall not be excessive. You're not going to have to pay $1 million bail for stealing a candy bar. A fine, which is a monetary punishment, shall not be excessive. You're not going to pay a fine of $1 million for dropping that candy wrapper. And lastly, a person cannot be punished in a cruel and unusual way. If you remember, we talked about how people would tar and feather the tax collector. Well, this was a punishment that could also be used in this time period by a government against their citizens. And the people decided, you know what, that's pretty awful, so we can't allow that kind of cruel and unusual punishment to happen. And again, why? In general, we have a period of British abuses of the people's rights, and they wanted to, again, be very specific as to what could or could not be done when in concern of someone's rights. A modern debate over cruel and unusual punishment is had over the process of waterboarding, where oftentimes this is used against like suspects of terrorism, and it induces the feeling of drowning. You feel like you're drowning, and this is debated as to whether is this indeed cruel and unusual punishment, and further, is a terror suspect who is not a United States citizen entitled to rights as they're outlined in the Bill of Rights, or is that only if you're a U.S. citizen? So that's kind of an interesting debate to be had as well. This brings us to Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So, translation. Just because a right isn't listed in the Constitution or Bill of Rights doesn't mean it does not exist. The Founding Fathers know they weren't perfect and may overlook something. That's what this amendment was for. It also, if you go back, uses a term that we learn in this class, enumerated powers. Powers from the Constitution that provide the federal government with very specific powers. Enumerated equals federal government powers. And they come from the Constitution. So, Here's a government authority. You're not allowed to fly a plane. Here's private citizen. Yes, I am. The Constitution says that even though it doesn't directly say it, I can fly a plane. Now, this is oversimplified. This is like for elementary school kids. But the point being, if you're properly trained and receive a pilot's license, then a government authority is not going to be able to strip that away for no reason. And here we are at Amendment 10. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. What's this mean? The powers of the federal government not specifically listed, that's enumerated powers. Specifically listed equals enumerated. There's that term again. Enumerated powers. They're left to the states and or people to decide. Reserved powers. So reserved powers, state powers. Federal government can't have these. This is also codified in the Constitution. One example of something that started out as an issue that was left up to the states based on reserved powers prior to a Supreme Court decision, now it is a federal matter, is same-sex marriage. This debate had been left primarily up to the states, but the Supreme Court decision, Obergefell v. Hodges, ruled that any state law that denied a marriage license to two consenting adults, regardless of sex, was unconstitutional. We'll get into things like interpretation of the law when we cover the Supreme Court, when we get through the three branches of government, which is the next section of the course. That is the end of the presentation. If you have any questions, by all means, reach out. Otherwise, I'll see you in class.